Thank you. Good morning, everybody. I wrote a position paper as regards the German-Swiss Rubik agreement, and I was asked to say some words on my position there. And yeah, we heard already a lot this morning about the agreement, so it's difficult to say something, to add something new here to the discussion. And also we heard many terms how these agreements are labeled or may be labeled. And well, the most extreme and the positive would be a milestone. We also heard the most extreme and the negative, the selling of indulgences. There's something in between, which could be nicely called the Swiss compromise. There's something, the utilitarian approach, Mr. Seher mentioned. And I also read a lot about it, calling it the fair compromise. My personal view on this is that it's a mere selling of indulgences, and that basically relates to the amnesty part of the agreement. In my view, a milestone could be only a label for this agreement from a Swiss perspective, as it's very positive on the image of the Swiss financial market. It's a milestone in securing the Swiss position on opposing to automatic exchange of information. It helps the Swiss in starting the white money policy, as we heard. It's very well for the clients, the German clients of Swiss banks. But what is in for the German government there? We heard the advance payment already, but like Mr. Baker pointed out, the question is, will there be any money flowing afterwards, after that advance payment has been settled against future payments? And that is exactly the problem in view of the amnesty, because for the amnesty, we heard under the agreement it's possible to pay a lump sum, to stay anonymous, and to be clear for the future. A heavenly gift provided here for a very specific group of German resident investors. Only those investing in Switzerland, undeclared money there. So in view of tax equality and fairness, the question arises, what about those who invested in Luxembourg, who invested in Liechtenstein, or anywhere else? What about those who already have been prosecuted based on data bought by the German Secret Service? Is that just? And here it's a question about the principle of equality. Under German constitutional law, there has been some considerations as regard amnesties. There's not a long history in Germany on amnesties. There has been one in 1990 and one in 2004. Both were partly challenged in front of courts, but we also heard the Constitutional Court is very lenient as regards the purchase of stolen data and their use. So the court is also very lenient as regards amnesties. For both, there were no problems identified as regards the principle of equality. A short word on those amnesties. In 1990, tax evaders were simply asked to declare their interest income previously undeclared. There was not even an obligation to repay any tax. In 2004, a similar situation, previously undeclared interest income could be regularized, this time against the repayment of taxes, however, on a reduced base. Those cases were challenged, and honest taxpayers, especially for the 1990 amnesty, asked for extension of the same treatment to them, in particular, not to pay any tax on the previously declared income. And the Constitutional Court set out, I may cite, that a bridge back to legality must be only built here and provided to tax evaders. It would be rather against the principle of equality to extend that bridge to already honest taxpayers. And what are the conditions for amnesty to be justified under constitutional law? Significant reasons may justify an amnesty. There must be a situation that needs to be remedied, like we have here with Switzerland, something where we say the past must be settled and we must start new over again. The legal consequences must stay within the framework of the law. In this respect, we should see that under German law, the General Tax Code, there's a constant disclosure facility available. So as a legal consequence is the full settlement of the charges and the criminal liability that seems possible. However, under that disclosure facility, anonymity is not granted. The idea is the taxpayer declares previously undeclared income, repays the taxes, and discloses its identity, which may then in the future ease following up on whether that person really followed and walked over the bridge back to legality. So it should ensure also an amnesty that in the future there's a more efficient taxation on that type of income that is regularized. And that is the problem here with the Rubik Agreement. We heard so much about possible loopholes, the famous insurance wrapper, the possibility that investors may move their funds after the entry into force within 6 months to other jurisdictions. So there's enough room to continue. And it's very questionable after past undeclared funds are regularized whether these people will really continue paying taxes as they should. So there's clearly a problem to be identified for the amnesty. No effective future taxation is guaranteed here. And in that respect, I see problems here as regards the rule of law principle and the principle of equality under German constitutional law.
Thanks a lot. Thanks for this communication that